Hello and welcome to Demand Better. Today we're going to be talking about the Wet'suwet'en, an indigenous group that is sovereign on their lands in BC, Canada, and is currently resisting a pipeline being put through their territories by the company Coastal GasLink. So, we're going to take a look at some of the details because this can often be a confusing case. A lot of people believe that because band councils have signed off on these projects that they're pretty much good to go, but the situation is a lot more complex than that, and even the Supreme Court of Canada would agree. So we're going to take a look at a video by Colonialism in Canada that does an excellent breakdown of the situation. It is called Colonialism in Canada, What is Happening at Unist'ot'en. So we're just going to take a little bit of a look at this, and hopefully that'll work out.
On Wet'suwet'en territory. On multiple occasions, all 5 clans of the Wet'suwet'en Nation have rejected Coastal GasLink's proposed pipeline.
Can you help us understand, sir, the distinction here between the Wet'suwet'en elected band council and the hereditary chiefs of the Wet'suwet'en clans? I understand that the council is on board with the pipeline, but the chiefs oppose it.
I will try to do so in the face of a lot of confusion and misinformation that has been provided. The Wet'suwet'en operate on a traditional system with respect to their unextinguished Aboriginal title to their lands, including the lands in question here. Fast forwarding to 21 years ago in 1997, the Supreme Court of Canada recognized that system.
I studied that.
Which I am the House Chief of, and also the Nicole case. All those cases we won.
The issue for the company and for the government
and just to be clear, the Supreme Court is not a neutral organization. Its primary responsibility is to uphold the laws and the system of the Canadian state. And so ultimately, to get the Supreme Court to agree with you that you have title and control over the lands, a little bit tough to do. And they were able to do it multiple times. So they have a lot of legitimate claim here.
British Columbia and Canada is that they need to address Aboriginal title, which has never been settled in British Columbia.
We told the world who we are, how we look at
because we never signed any treaties. That's the main reason.
And yet, the governments and the industry are still dancing around.
The Supreme Court of Canada made no final determination, but it did recognize that the title holding system is the hereditary chiefs. People talk about it being complicated. It is not complicated.
So, just to repeat what he just said, the hereditary chiefs, according to the Supreme Court of Canada, hold title to the land. They are the legitimate controllers of the land. Therefore, the band council signing off on this basically should not be done without consulting the hereditary chiefs, without arranging this first. It seems like Coastal GasLink and these other companies tried to rush it past through the band council, which is, it's as an elected body, you need a lot of money to run in elections, so it's a lot easier to sway those elections with corporate money, which is not to say that that's absolutely what happened in this case. I actually don't know the details of those elections, but it is a fairly common thing when there's resource projects at stake for companies to lean on the part of the Indigenous governance system that the Canadian state tends to view as more legitimate. So let's take a look at a little bit more here.
It is a little complicated, but this is what you need to know. In short, both Wet'suwet'en and Canadian law recognize the hereditary chiefs as the rightful decision makers on Wet'suwet'en land.
Both legal systems recognize this. That is,
rights and title have never been extinguished, nor surrendered through treaty.
That's a lot of agreement.
By all means, they are sovereign
between
people.
Separate legal systems. Just saying.
As for the band councils,
they deal with the question of on the reserve, water, sewage, those other issues.
At this point,
band councils have specific responsibilities, and those responsibilities do not involve giving land to corporations. That is not in their power. That is not in their jurisdiction. So why are they doing that?
you should at least know more than the guys carrying the guns.
I think my understanding of the Algamuth, and it's a basic understanding, is that the First Nations in that territory had tenure over that particular area of land, and they've never ever relinquished control of that land.
It is pretty clear that Sergeant Rose has no idea that he's on the land he is talking about, as the Wet'suwet'en were plaintiffs in the case he is referring to.
They've always turned away outsiders. There's never been anybody permitted into that territory. So because of that long-term history and record, of not permitting outsiders into that territory, the court said, true, you've never ceded that territory.
Let's go back a little further to the Indian.
I'm not sure just how wrong he is. I just know he's wrong.
Act of 1876, which combined numerous pre-existing colonial policies aimed at eradicating indigenous cultures and governments. The act was designed to remove indigenous people from the land, put them on reserves, replace their governments with the dependent band council model, and to assimilate them into Canada. All of this was done to facilitate colonial settlement and resource extraction. In the 1880s, the act was amended to criminalize all involvement in.
So, even though this is unceded land, and that gives these folks technically more claim to it, the reality is that almost no Indigenous peoples in Canada actually ceded their land. In all the treaties and most of the agreements, it was like a land sharing agreement, maybe, at most. Sometimes we just, like, took a fishing agreement and went, we got your land now. Like, it was lying. We basically lied to these people. We did not beat them with the strength of arms. There was a very long period of Canadian history when the Canadian government would have lost a war against a confederacy of First Nations because we wanted to fight them piecemeal. We wanted to fight them a little bit at a time and destroy them a little bit at a time because we knew we weren't strong enough to actually take these folks on. And that's part of the reason why they set up this whole clandestine residential school system, all these different ways to basically destroy the people who we had signed treaties with. So as soon as we kidnapped all their children the first time, I think we basically invalidated any treaties of friendship or land claim that we had. So if we want to have a legitimate Canadian state, Indigenous reconciliation, and even a decent amount of land back, which is not as scary as it sounds. It doesn't involve, like, deportations or killings or anything. It just involves, like, recognizing, you know, instead of a couple of white guys owning all the land in Canada, it'll be, you know, partially owned by the people who were initially here. Wouldn't that be nice? So, you know, it's not that scary. And it's basically the only way that we could end up with a legitimate Canadian state, because we tossed that legitimacy right out the window the moment that we did anything in relations to the residential school system. If not more, if not other things earlier than that, we broke those treaties. We are the ones who don't have a legitimate claim to this land, not them. So, it's kind of unfortunate the way that this often gets talked about. So,
in traditional governance systems through the banning of the.
You know what? Definitely check out this video. I won't go through the whole thing because I want you to check it out yourself, and because, frankly, I think this is an Indigenous person, and probably just better to get it straight from the source. This person's done a lot of research, they have a lot of knowledge, and frankly, it's a pretty impressive video, so feel free to check it out. I think that would be very healthy. What should we take a look at next? I think